One courtroom. Multiple lives changed in minutes. A fatal crash plea, a felon caught with a gun, and a murder defendant rejecting a 45-year deal. What happened next shows how serious sentencing day can become.
Ma'am, would you please raise your right hand? Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English, so help you God? Yes, sir. Thank you. All right, sir, are you Johnny Jacobo Ramon?
Yes.
And Mr. Burbank, will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Jacobo Ramon, in cause number 24, DCCR 1372, you're charged with a second-degree felony offense of accident involving death from July 16th of 2023. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they charged you with?
Yes.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney, you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a cap of 15 years in prison. There would be a dismissal in the other case, which means you're leaving your punishment up to me. And as long as I give you 15 years or less, you can't change your mind and appeal your case. Do you understand?
Yes.
You have a right to have a jury come decide if you're guilty or not, and then you could leave your punishment up to that jury. If we go forward this way, you're giving up that right. And is that what you want to do?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
Objection, State.
It's admitted. Is there any evidence that Mr. Jacobo Ramon is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That will give me more information about you and your case. And then we'll come back later for sentencing. Anything that you think is important for me to know, make sure you tell Mr. Burbank that, and he will present it to me when we come back. Okay, thank you. You can go back with the bailiff. Are you Michaelan Jones? And Mr. Rojas, will your client waive the formal reading of the motion?
He will, Your Honor.
Mr. Jones, in cause number 22-39715, I have a motion to revoke your,
I'm sorry, just
Oh, that's okay.
we're only going to count 2, 3, and 4 whenever you get to it.
Thank you.
That is correct. Thank you, Mr.
I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation July 18th of 2022 for the offense of possession of a controlled substance, and that was a 3-year deferred probation. Is that correct?
Yes, ma'am.
And it looks like the agreement is for you to go forward on counts 2, 3, and 4 in that motion. Count 2 alleges that you violated your probation by committing the offense of flight from an officer May 17th of 2023 in parish of Point Coupe in Louisiana. And is that true or not true?
Yes, ma'am.
True or not true? Thank you. Count 3 alleges that you committed the offense of illegally carrying of a weapon May 17th of 2023, also in the parish of Point Coupe, Louisiana. And is that true or not true?
True.
And then count 4 alleges that you committed the offense of possession of a Schedule I drug on May 17th of 2023, also in the parish of Point Coupe, Louisiana. And is that true or not true?
True.
Did you enter your pleas of true to counts 2, 3, and 4 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Jones is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 2, 3, and 4 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation, and at this time find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 21 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Judge, if I may, the motion was filed in June of 2023 based on offenses that happened in May of 2023. He's been in Louisiana custody since those offense dates of May of 2023. However, our hold for this motion to revoke didn't get placed on him until October 7th of 2024.
And Judge, Mr. Rojas, I'm sorry to interrupt, Mr. Rojas, and I have conferred, the state is not opposed to the court giving this defendant the credit for the time he's been in jail while this case is pending. You may recall, I've researched the issue. I actually briefed it and I gave the court that authority.
You did.
I think you have that authority if you choose to award him that credit.
Okay, so what I'm thinking I would do, I'm not going to go back to the offense date. I think the cleaner way to do it is to go to the date of the motion,
Okay.
which is just a month or so
Right.
or less. But I think that at least for our purposes, if somebody's looking at it, they'll see motion was filed on that date, warrant was issued, but there wasn't a hold place for some reason.
Correct.
And so I'm going to allow credit from June 7th of 2023. In whatever time that adds up to, I will, we'll get that done. Okay?
Thank you, Judge.
All right, so Mr. Jones, I am handing you the trial court certification, well, 2 things. One, showing that this was an agreement, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. All right, good luck to you, sir, and thank you, probation, for being here as well. This is kind of long. I needed to see this before. Let's see. Yeah, it looks like it. No, that's okay. I see it was just fine.
That's mine.
Good morning, you're Crystal Moore. All right, y'all give me just a second to go through a couple things here.
Either it happens or it doesn't happen. We'll come back.
All right, so are you asking for, I know so there's a motion to revoke probation in 23 DCCR 2026, and there's no bond set in that one, correct?
Correct.
And then in 25 DCCR 0496,
I think there's a $6,000 bond in there.
I showed a $2,000.
well,
Take two.
That's what I showed.
can y'all help me figure out that real quick with the actual bond? I know you're not asking for that one to be reduced.
No, Judge.
So really, we're just talking about the other one
The
anyway.
motion to revoke.
Okay, so on probation for DWI with a child passenger, and the new offense is a theft, correct? State jail felony?
That's correct, Your Honor. And there's
Yes,
also
Judge.
a case that was, she was arrested for possession of controlled substance that has not been filed yet.
Okay, probably waiting on labs on that?
Yes, ma'am.
Okay, and that same date as the theft, or is that something different? Do you know?
I don't have anything on it.
Okay,
October of 24 is what my notes indicate on it.
And this was December of 24. Theft, I believe.
Well, I'm a little confused. I've got an October theft, and I also have a November theft, according to my summary of her criminal history. Both of them I list as,
Our indictment shows an offense date of December 26, 24.
I'm not sure.
okay, that's okay. So I want to make sure, and Mr. Coleman has filed a response, and part of that response includes the information that Ms. Moore was previously convicted of the offense of robbery, initially placed on a deferred probation that was revoked in 2017 on that case. Also a conviction for aggravated assault out of Tarrant County from 2016. And then we've got the probation that was granted here on the driving while intoxicated with a child passenger. Let me get this pulled up again real quick. And while on this probation has been arrested for two new offenses, the theft and the possession of a controlled substance. Is that?
That's correct, Judge. And since you got my motion, or my reply, you've already read it, I'll just be brief. I just want to add that according to my recitation of her criminal history, it looks like she's got a total of 5 pending cases that include an unauthorized entry of an inhabited dwelling out of Louisiana.
I see that as well. And there, do you know if there's warrants issued for those? I know it's hard to get information. Do you know anything about
I
those?
don't know, Judge. This is the first I'm hearing about that when I saw that in the motion. I don't know if there's any holds on her from Louisiana or not.
All right. Mr. Rojas, do you wish to call any witnesses?
Briefly, Judge, I'll call Ms. Moore.
Ms. Moore, best you can, raise your right hand. Do you swear affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Go ahead, Mr. Rojas.
Ms. Moore, where are you from?
Correct.
And have you lived in Port Arthur all your life?
Yes, sir.
All right. Who do you live with when you're not in jail?
My family.
Speak up for us.
My family, my mom.
Okay. And who all lives in the home with your mom?
Me, my mom, and my kids.
Okay. And how many kids do you have?
5.
And what are the range of their ages?
My youngest is 1, and my oldest is 11.
And is your mom taking care of those kids right now?
Yes.
Okay. And my understanding is that your mom is also ill right now.
Yes.
What is the nature of her illness?
She has a brain tumor and has to undergo treatment and surgery.
And is there a surgery scheduled for that already?
Well, she actually postponed it due to she has no support with my kids right now.
Is she the only adult in the home with your kids?
Yes.
All right. And that's one of the reasons you want to get out, to make a bond in this case, so that you can go out and take care of your kids, make arrangements for them, because your mom's going to have some surgery and she won't be able to do it anymore.
Yes.
All right. Do you have any income when you're not in jail? Do you have any income coming to the home for you?
Yes.
What do you have?
SSI and child support.
SSI. How much do you get in SSI benefits?
1,000.
Is it every month?
Yes.
And child support, how much do you get?
140
How often is that?
every 2 weeks.
140 every 2 weeks, so that's $280 a month there. Do you have a bank account in your name?
Yes.
Do you have an idea of how much money is in the account right now?
Probably like 500.
Do you own any property that you could sell to help you come up with money for this bond?
Yes.
Is your mother or any other family members, are they willing to help you come up with money to make the bond if the judge will set a bond for you?
My mom, she can proceed with her procedure.
Your mom's willing to help you out? Okay. And that's what you're asking the court to do this morning, set a bond on the motion to revoke on this DWR, right? And the main reason for that is so that you can get out and help your mom take care of her kids and get her past the surgery.
Yeah, like I understand that in the future I might have to serve time for my actions, but that's like my goal was to get out so she could undergo treatment and I could fully prepare her and my kids so when I do have to serve time.
Okay, pass the witness.
I have no questions for this defendant, Judge. I stand on the motion. I don't have anything to add to the motion. If the court's inclined to grant this defendant a bond, I just simply ask you to consider the factors listed in that motion, Judge.
Well, I'm looking back just for everyone, for the record, at the pre-sentence report that was prepared in cause number 23, 2026, and I've reviewed that. I've also reviewed, there's a handful of jail incident reports that everyone was given a copy of as well. Based on the nature of Ms. Moore's prior convictions, which range from, give me just a second to go back out through this. Beginning as a juvenile, back in 06, 07, extending all the way through 2012 as a juvenile, assaults, thefts, violation of court orders, and then we get into adult, and we've got more thefts, county jail, theft of property, then we get into felony, we've got a robbery, given a probation, that was revoked, got a theft from a person, and then we've got an aggravated assault with a deadly weapon, that one from Tarrant County. Now on probation, given all the opportunities, multiple allegations in the motion to revoke probation, that Ms. Moore has not apparently done much of anything while on probation to get the help that we've been offering her. In addition to having two new offenses, a possession and another theft, I find that it is in the best interest of our community that there not be a bond set in cause number 23 DCCR 2026. I appreciate the arguments and I feel and have empathy for what your mom is going through, but you should have thought about that before you kept doing what you were doing. So you can go back with the bailiff. I'll set the case for an announcement on the motion and the new case.
Thank you, Judge.
Thank you.
Good morning, sir. Are you Rontez Williams? And Ms. Holmes, will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Williams, in cause number 22-40090, you're charged with a third-degree felony offense of fraudulent use of identifying information from January 20th of 2022. And how do you plead to that charge? Speak up, please. Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them. Holmes, do you fully understand that? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Speak up.
Yes.
She has to hear you too over here, all right? They're just taking everything down. Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number one.
No objection.
It's admitted. Is there any evidence that Mr. Williams is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of fraudulent use of identifying information. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes, all right? Good luck to you, sir. You can go back with the bailiff. See, Mr. Parker on Laddie Johnson. Good morning, sir. You're Denzel Lewis. And Mr. Lewis, you were previously in court, entered a plea of guilty to the third-degree felony offense of unlawful possession of a firearm by a felon. The agreement was for a cap of 6 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Judge.
Are there any additions or corrections?
Just argument from the defense.
Not from the state.
In addition, I have received the jail incident reports, which have been turned over to counsel. Have you both had an opportunity to review those?
I have.
Also, I have received this morning and now reviewed, it looks like 4 letters of support that Ms. Holmes brought today. Mr. Smith, have you had an opportunity to review those as well? All right, then Ms. Holmes, you may proceed.
Thank you, Your Honor. In looking at the PSI report, Mr. Lewis does have obviously previous criminal history spanning from juvenile and to adulthood. The priors that he has, it appears, with burglary of a habitation. It looks like 3 cases, but they ran concurrently, in which he was placed on probation and had a revocation, in which he was sentenced to 8 years in TDC. He has since been discharged from that, Your Honor, and after being released, there was this traffic stop, which resulted in a firearm being found in the vehicle in which Mr. Lewis was driving. Obviously, in reading his response to the PSI officer, I would allow him to elaborate more on that. Obviously, he did plead guilty to the offense, taking responsibility, and we are seeking probation in this case, Your Honor. We believe that at this point in Mr. Lewis's life, he understands, obviously, being incarcerated before, that it's not somewhere that he wants to go back and spend potentially 6 additional years of his life. He would like this opportunity on probation to have that opportunity to spend and get back on track with employment, to take care of his family and provide for his family. And reading those support letters, Your Honor, he does have support here from family and friends in the community that are willing to step up and help him to make sure that he is a productive citizen and he gets back on track. He understands that there's just certain things with being a convicted felon that he cannot do. And I think at this point he understands that, Your Honor, and we are asking that the court give him the opportunity to be placed on probation and to finish his term while on probation.
Well, I guess before we go any further, I want to make sure I understand, because Mr. Lewis, your version of this is that it wasn't your gun, it was in your girlfriend's purse, and you didn't even know her purse was in the car, much less the gun was in the purse in the car. So either you are guilty or you're not guilty of the offense. And so if you knew about it, then you're guilty. If you didn't, then a jury needs to decide.
I'm pleading guilty because I was driving the car, and by me driving and then finding the gun,
But the law, that's not what the law is. Okay? So you don't get to just take a deal or plead guilty because that's what you want to do. When you were here before, you stood in front of that clerk, you put your hand up, swore that you were going to tell the truth, and I said, are you pleading guilty freely and voluntarily? Or are you pleading guilty because you did what they charged you with?
And I was, and I still am.
Okay. All right, Mr. Smith?
Judge, I think he's been given probation before. It was not successful. He's been revoked. The actions in the jail clearly show he doesn't have any respect for authority or rules. I don't feel like he's a proper candidate for probation, so we're asking for a 6-year sentence in TDC.
So, Mr. Lewis, one thing I noticed in several of these letters that friends and family members said, I think 3 of them actually used the word respectful, that you're a respectful young man.
At this point, the hearing turned from paperwork to accountability. The judge reviewed criminal history, jail conduct, and failed second chances. In sentencing, behavior after arrest can matter just as much as the charge itself.
What has been going on in our jail is the furthest thing from respectful that I've seen. The number of times, and the fact that I have to say this out loud, the number of times that you choose to masturbate in front of the officers on purpose is ridiculous.
I speak on the,
Sure.
the case wasn't on me. Somebody else had a case, and the woman even talked to the lieutenant to get it removed up off of my file, but it still shows up. That was not on me. It's somebody.
It's more than one time.
But
So hold on. So on April 14th, let's just go through them. On April 14th, you were in trouble for not being in your bunk, that you had been given several orders to go to your bunk. You proceeded to walk around yelling, "Bitch, stop talking to me." So that's from April 14th, last week. Then on April 7th, it alleges that you had your hands in your pants, moving in and back and forth, that you were told to take your hands out of your pants, and that you had been told before, or this officer had been briefed on the fact that you were known for doing this. Your response, according to this, is that that person should have asked the officers how big your penis, anyway. Since they want to be talking about you, they should have told them about that too. Then, on March 25th, before that, a week, so another officer, and these aren't the same officers, it's not the same person saying the same thing about you, somebody has some vendetta against you. So on March 25th, started to do rounds. Notice that you were watching the person doing rounds, had his hand over his midsection as if he was rubbing on himself. March 18th, another different officer. Notice monitoring the bunk. There you are, laying on your back, stroking your penis in a back and forth motion, told not to do so. January 24th, 2025, you're in trouble for walking around. This one, notice the way you're laying on your bunk in a way, making motions under the blanket, walked past, turned around to see if you were still doing it. Then you supposedly look at this officer and say, "I'm not doing anything," while you lifted the blanket up for that officer to see it. January 4th, another time, being told to be quiet, do what you're supposed to do, didn't do it that day. December 29th, another issue of not following the rules. December 17th, another infraction for arguing and not following the rules. So if there was one time when they got the wrong person, that's one thing. That's over and over again, you disrespecting female officers who are in there just doing their job.
I don't know, sleep on my bed.
Sir,
I don't know.
we're really going to do that?
You ask me and I'm telling you, I sleep on my back. I have sisters. I have a mama. I don't do that. Them people write whatever they
They're
write.
making this up on you. That's terrible of them to do
If
that.
you look at my cases report, ma'am, I don't have any cases on none of that. I don't have any time. I'm not on no restriction on none of that
Okay.
up in the county.
You were off parole, the way I do the math, less than a year.
Parole.
So you did your whole 8 years?
Yes, ma'am.
What'd you do in prison to have to do your whole 8 years?
I was in SIG.
For doing what?
Just tattooing, contraband.
Not following the rules while you're in prison. I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by a felon. Sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal, and you're lucky that this was the agreement. Mr. Smith was generous. The fact is, you could have been enhanced to a second-degree felony because of your history, and you're lucky you weren't. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, you know this, but I'm required to read this to you. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk to Ms. Holmes. You can go with the bailiff. Okay, again, sir, you're Dalton Batiste. And give me just a second. Mr. Batiste, in cause number 24, DCCR 0407, you're charged with the state jail felony offense of possession of marijuana from October 14th of 2023. And what that means in that case is if you go to trial and you're found guilty, the range of punishment would be between 6 months and up to 2 years in prison. Do you understand?
Yes, sir.
And then in cause number 24, DCCR, why is it sealed?
Because he's never been back in custody.
Oh, but now that he's done over there, maybe we can get him. Okay.
That's what Mr. Coleman tried to do, was ready to come to our jail.
My understanding, Judge, is he's getting moved today to county.
Okay.
Anyway, for whatever that's worth.
Okay, perfect. So again, in 24 DCCR 0917 and 0918, you're charged in each of those cases with the first-degree felony offense of murder from January 10th of 2024. The indictment in each of those cases alleges that you were previously convicted of robbery, a second-degree felony, October 26th of 2018, and also unlawful possession of a firearm by a felon on that same day. And what that means in those two cases is that if you go to trial and you're found guilty, the range of punishment would be enhanced. The minimum punishment would be 15 years in prison up to 99 years or life in prison. Do you understand? And then in all three of those cases, I have here on the computer some documents, the plea bargain rejections that you've signed with Mr. Gertz, that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. And it looks like the agreement would be for a 45-year term in the institutional division of the Texas Department of Corrections in the two murder cases, and I guess a 2-year term in that state jail felony that would run concurrently. All of them run at the same time. Do you understand the possible consequences if you go to trial, and what your options are if you wanted to enter pleas of guilty? And do you want to reject those offers and have all of your cases set for trial? Okay, we'll get those cases set for trial. Obviously, if there are any pre-trial issues or legal things that we need to take care of prior to.
Sorry, give me just 2 seconds, Judge.
Okay, we good?
Yeah. Sorry, just to clarify, he was concerned because you said both of the priors were on the same date, and I said that was the date he was sentenced, not the date of the allegations.
Okay.
I was just clarifying that.
Okay, the convictions were from the same date.
And I was clarifying too that it's better that if it were
True.
separate days.
Right. Okay, so you want to reject those offers and have all of your cases set for trial, is that correct? Okay, then we'll get it set on the trial docket. Obviously, if there are any legal issues that we need to take care of ahead of time, get whatever you need to filed so that we can take those up prior to any trial date. That way, there's no worries when we get to a trial of going forward or not.
And
All right.
Judge, I don't know if Mr. Coleman has decided on behalf of the state if he plans to try both of the murder cases together. The marijuana is a separate, totally separate incident, and whatever happens with that is what's
I
going
don't
to happen.
think that's the concern.
But I just want to,
The state intends to file, if we haven't already, a motion to consolidate these two cases in trial.
Okay, you've already filed it.
okay.
Okay.
So we would anticipate trying both of them at the same time.
Perfect. Okay, sounds
Okay,
good then.
thank you, Judge.
All right, you may go back with the bailiff. Just a second while I find the motion. This looks weird on here for some reason. It's the order. The order for the motion to revoke, looks like it's in here twice, but I don't see the motion in the file. Cynthia Campbell. I need a clean one so that I can write on it. Thank you. Hang on just a second. Unless, was it filed back in 2023? Or is that another one?
March 25.
Okay. It's not on here.
Here it is, 5/23.
No, we need one from 25.
Okay, I'm sorry, Judge.
There should be a new one. March 4th of 25, I've got, oh wait. This is probably it. Do you see that 22-40282? I don't know who names those, but
That's how it was e-filed. Sorry.
that's okay. Who e-files them? Them?
Yes.
Okay. Would you make a note so we can make sure they know that they need to call it what it is?
Yes, ma'am.
No, it's, so on my screen, it doesn't say motion to revoke. It just says the cause number and PDF dot 3 pages. It doesn't say that it's the motion to revoke, so I don't know what it is. So I need it called that so I can find it, because we're paperless and it's easier. Okay. Yeah. All right, you're Cynthia Campbell. I got it now. Thank you. And will your client waive the formal reading of the motion?
She does, Judge.
All right, let me get my stuff together here. Ms. Campbell, in cause number 22-40282, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 12th of 2022 for the offense of aggravated assault with a deadly weapon. And that was a 10-year deferred probation. Is that correct?
Yes, Your Honor.
I'm getting there. It alleges that you violated your probation. Count 1 alleges that you failed to avoid persons or places of disreputable or harmful character, specifically avoiding association with any person previously convicted of a crime or being at any location where a crime was committed. And is that true or not true?
Yes, Your Honor.
True or not true? Thank you. Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true?
True.
Count 3 alleges that you failed to immediately report to the probation officer your new address. Is that true or not true?
True.
Count 4 alleges that you provided a urine sample January 6th of 2025 that tested positive for methamphetamine amphetamine, cocaine, and tetrahydrocannabinol. And is that true or not true?
True.
Count 5 alleges that you provided a urine sample January 8th of 2025 that also tested positive for methamphetamine, amphetamine, cocaine, and tetrahydrocannabinol. And is that true or not true?
True.
Count 6 alleges that you failed to successfully complete treatment at the Melton Center for intensive inpatient treatment. Is that true or not true?
True.
Count 6 alleges that you failed to submit to alcohol or drug screening November 16th and December 9th of 2024, and then January 7th, January 14th, January 24th, and January 28th of 2025. And is that true or not true?
True.
And then count 8 alleges that you're behind in your court-assessed fees. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 8 freely and voluntarily?
Yes, Your Honor.
And did you plead true to those counts because they're all actually true?
Yes.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, Your Honor.
Do you fully understand them?
Yes, Your Honor.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, Your Honor.
And, hold on a second, I just lost it. There we go, okay. And it's for a term. Okay, state tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Ms. Campbell's not competent?
No, Judge.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 1 through 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. I am making an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis. All right, good luck to you, ma'am. You can go back with the bailiff.
Thank you.
Some defendants accepted deals. Others gambled on trial. But every case carried the same lesson: choices bring consequences. And the courtroom moved forward one sentence at a time.